All right, are y'all ready to continue? I'm ready to continue. Turn with me to the next page in the book, and let's talk about the longest chapter in the book. This is chapter 4 in the skinny book, chapter 5 in the fat book. And let's talk about real estate brokerage offices. Now, real estate brokerage office, number one, you're required to have an office. If you're an active broker, you've got to have an office, and that office must be at least one room in an enclosed building. You can't have your office in a trailer down on the beach or something like that. It's got to be in a building of stationary construction, and the broker is bound to store his books, records, and files at that location. Broker's not required to have an air-conditioned car, a cell phone, or anything like that, but you are bound to have an office. You're bound to have an office, and you're bound to tell the DBPR where your office is. So if they want to send out an investigator, they'll know where you are. Now, every real estate broker is bound to have a sign, and that sign is to be displayed on or about the door. And in fact, hold on, I'm going to go get my sign. Here's exactly what the sign's supposed to look like. It's bound to have the word licensed real estate broker on there, and absolutely no synonym will do. Now, the word license can be abbreviated to LIC, but other than that, it has to be those exact words, and it has to have your name. Now, I'm a sole proprietor with no corporation. Now, if I had a corporation, or if I had a fictitious name, the fictitious name would also have to be on the sign. So if I were doing business under the name of Clymer Realty, the sign would have to say Clymer Realty, Ron Clymer, licensed real estate broker. But since I don't have a fictitious name, that's all the sign says. Also, if I were incorporated, Clymer Realty Incorporated, sign would have to say Clymer Realty Incorporated, Ron Clymer, licensed real estate broker. And so that has to be on there. Nothing else will do except the phrase licensed real estate broker. Now, there was a time in history when there was a minimum size for the letters on that sign. The truth is, today, your letters have to be a reasonable size. So if you're in a building, like we're in the Rosemont building, and we're the same as everybody else up and down the hall, that's a sufficient size. If your sign was the size of a postage stamp, that probably wouldn't be a sufficient size. Now, it asks questions on the exam about branch offices. Now, there's a minimum of one office, but there's no maximum office. You can have as many offices as you want to. There are several companies that have 30, 40, 50 branch offices. Now, a branch office has to be registered with the DBPR. Now, there's a fee for that. They don't care on the exam that you know how much the fee is, but they want to know for sure that you know there is a fee for that. Now, a branch office, and they love to ask questions about is this or is this not a branch office? And here's the key word. The key word is permanence. If it's a permanent location, it has to be registered with the DBPR as a office. Question on the exam, for instance, says Broker Bob has a subdivision listed where he has a construction trailer where the salespeople get in out of the bad weather and they store sales brochures there. Well, that's what the question says. Then all you got to do is at a branch office. And the answer is no, because all they do is store sales brochures there and get in out of the bad weather. How do we know that's all they do? That's what it says on the test. Now, if the test question says, Broker Bob has a subdivision listed, he has a construction trailer where telephone's been installed, Sales meetings are held there once a week. Salespeople are assigned to that location. Books and records are stored there. Don't forget, you can only store books and records at the office. So if books and records are stored there, that would be a slam dunk all by itself. Also be aware that branch offices cannot transfer from one location to another. So if you have, for instance, Broker Bob has his main office in downtown Orlando. He has a branch office out in Altamont Springs. Now, if he wants to move the main office from one part of Orlando to another, the main office will transfer. But he wants to move the branch office from Altamont Springs to Longwood. Well, that branch office will not transfer. And so what you can do is open a new branch office in Longwood. So now you got the Longwood branch, you got the Altamont branch, you move all the furniture and equipment and phones and everything up to Longwood and just let the Altamont license expire. And you could notify the DVPR that we're gone, but it would still show as being a branch office. In fact, if you got up to Longwood, things didn't work out, and you wanted to come back to the Altamont office, you could get what's known as a reissue of that license with no fee. Now, active real estate brokers must have their sign with, as I said, name of the broker, trade name if you have one, and the word licensed real estate broker. By the way, that phrase, licensed real estate broker, that's the only phrase that will do on this sign. However, any other advertising that you do, ad in the newspaper, website, Craigslist, yard sign, business cards, letterhead, you have to make it clear that you're a real estate broker, but you don't have to use that phrase. You can use any phrase that makes that clear. Now, advertising is always in the name of the broker and always under the supervision of the broker. Sales associates may not advertise real estate in their own name. You see a big old billboard that said, "Call Joe Salesman," it better say with XYZ Realty down there in the margin somewhere, because if it doesn't, it's a violation. Advertising also has to be worded so that anybody looking at that ad would know they're dealing with a realtor. If I have a house listed over here in the neighborhood, I run an ad that says, "House for sale, nice neighborhood, call this number." Well, the ad implies that I own the house, when that's not true. I'm just brokering the house. That would be misrepresentation to run that ad that way, and that is called a blind advertisement, and the FREC does not like that. Also, does everybody recognize that the internet's just a giant advertising medium? So if you're putting up a website that doesn't clearly identify yourself as being a licensed real estate broker, that's a violation. Also, any advertising, if Mr. Salesman wants to use his personal name, that's okay, just so he uses his first name and his last name. You can't run an ad just using your first name. If it says, "I'm with XYZ Realty, ask for Joe." No. It's got to say, "Ask for Joe Salesman." And also, now it could say, "Ask for Mr. Salesman" if you wanted to. FREC does not require that you have your phone number in the ad, or a salesman could run an ad, "A 3-bedroom, 2-bath house for sale, XYZ Realty, call this number." And that number's his cell phone or whatever. As long as XYZ Realty doesn't object to it, he could do that. FREC certainly doesn't object to it. Also, and if you stop and think about it, lots of ads might not even have any use for a phone number. You might have something other than a phone number. Yard signs, classified ads, any kind of promotional advertising must include the name of the brokerage firm. If it says, "Ask for Joe Salesman with XYZ Realty." And now, if Mr. Licensee wants to sell property himself by owner, so here's Joe Salesman, works for XYZ Realty, but he's going to sell his house by owner. he puts an ad in the paper, 3-bedroom, 2-bath, nice neighborhood, call this number. Now the number is not the office number, it's his home number. So the people call, they come out and look at the house and they say, Joe, we kind of like your house, but we kind of wanted to make you an offer. Before we get to meaningful negotiations, I'm not sure what that word means, but before we get to meaningful negotiations, Joe would be bound to say, well, before you make me an offer, let me disclose to you that I'm a licensed real estate broker or real estate salesman. And so make that clear to them. They say, that's all right. So they end up buying the house. They negotiate with Joe. Now let me talk to you about telephone solicitation. In Florida, we have a law through the Department of Agriculture where it's called the do not call list. So if somebody wants to get on the do not call list, and as of July 1, 2012, this is absolutely free. So Mr. General Public has his name put on the do not call list. Well, I'm sitting here and I've decided that the cold calling is a wonderful way to advertise. So I'm sitting here calling everybody on Elm Street, everybody on Pine Street, everybody on Willow Street. So I'm sitting here calling, hi, Mr. Seller, I wonder if you folks been thinking about moving perhaps now or in the near future. I call Mr. Seller that's on the do not call list, I can be fined up to $10,000. I can be fined up to $10,000 through the Department of Agriculture. It's a good idea that Mr. Broker has a written policy addressing that, because if Mr. Salesman makes that phone call, Mr. Broker is liable for that money. Also, does everybody know that you can't call people before 8 a.m. or after 9 p.m.? And now we have a federal law, but they tell us at instructor seminars that the only questions on the state exam are about the Florida law. Through the Department of Agriculture, fines $10,000, and you can't call before 8, you can't call after 9. Now let's talk about escrow accounts or trust accounts. Escrow accounts, brokers are not required to they are required to keep earnest money separate from any other money. So everybody's familiar with, I sell a house on Sunday afternoon, happy young couple wants to buy it, they want to sign a contract, and I ask them to give me a earnest money deposit, a binder deposit. Now we like to say this like this is some kind of official thing. The truth is you don't have to do this. We just discovered a long time ago that everything goes better if you do. Oh, hold on a second. My phone's ringing. Hello, this is Clymer School of Real Estate. Yes, we have the 45-hour post-license class. It's a barrel of fun. It's coming up in about a month if you'd like to enroll in that, and you need to take that before you renew your license the first time. So if you'd like to enroll in that, you can call Kathy at 407-822-3926. And, excuse me? That sounds like a good idea. All right, well, we'll see you at that 45-hour class, and so give Kathy a call, and we'll be in touch. All right, bye-bye. Pardon me, I had to take that call. Somebody calling about our 45-hour post-license class, and I would urge y'all to come to that, but let's get you through the state exam first. Now, so Mr. Buyer gives me the $5,000 escrow deposit. Now understand this, real estate broker doesn't have to maintain an escrow account, but if he's going to handle escrow money, he does. So they give me the $5,000 binder deposit. Now you can just about be certain the question is going to ask you about the salesman turning the money over to the broker, and it's also going to ask you about the broker getting the money in the bank. Now here's the rules. The salesman is bound to turn the money over to the broker immediately. Now what does immediately mean? It means by the end of the next business day. So if Mr. Salesman collected the money on a Saturday morning, he is bound to turn that money over to his broker no later than Monday close of business. So the salesman collects the money on a Saturday morning. He's bound to turn it over to the broker by the end of business on Monday, end of the next business day. Now, that's the end of the story for the salesman. Once he turns it over to the broker, he has fulfilled whatever obligation he has. Now, Mr. Broker has the duty to get the money in the bank, not Monday, not Tuesday, but before end of business on Wednesday. The day the salesman collects it is not the first day. The next day is the first day. In our example, Monday, Tuesday is the second day. Broker's bound to have the money in the bank by the close of business on Wednesday. Well, let's try that again. Let's say the salesman collects the money on Tuesday morning. He collects the money on Tuesday morning. He's bound to turn it over to the broker by Wednesday close of business, which is the first day for the broker. Thursday is the second day for the broker. Friday, close of business, the broker's bound to have the money in the bank. You're going to see both of those on the test. When does the salesman have to turn it over to the broker, and when does the broker have to have it in the bank? Now, here's the deal. Also, don't forget this. And by the way, don't forget this is related to a lot of things. The broker is responsible for the acts of the salesman. The salesman is not responsible for the acts of the broker. Well, if that's true, what if the salesman collects the money on Tuesday morning? He collects the money on Tuesday morning. He doesn't turn it over to the broker on Wednesday as he should. He doesn't turn it on Thursday as he should. He finally turns it over to the broker Friday afternoon at 2 o'clock. Well, the broker doesn't get an extension because his own salesman is inept. He's bound to have the money in the bank close of business on Friday. Does that make sense? Or Mr. Salesman collects the money on Tuesday morning. He turns it over to the broker 10 minutes later. That doesn't run the clock up. Wednesday's still the first day. Thursday's still the second day. Broker doesn't get it in the bank till 4:30 Friday afternoon. That's fine. Also, if the salesman collects the money and the salesman decides, I'm skipping town with this money, the salesman would be bound to return that money the salesman skips town with the money, the broker would be bound to return that money to the injured party because he's responsible for the acts of the salesman. Or the salesman collects the money, turns it over to the broker as he properly should, and the broker skips town with the money. The salesperson would not be bound to return that money to the injured party because he's not responsible for the acts of the broker. Broker's responsible for the acts of the salesman. Salesman's not responsible for the acts of the broker. Everybody with me on that? By the way, I promise you there's nothing on the state exam that you need to know that's not covered on these videos and my YouTube videos with the math. We got everything you need. So if it's on the Florida state exam, it's in these videos and the videos that are on YouTube with the math. But let's talk about escrow accounts. Now, a lot of brokers today are choosing not to maintain their own escrow account. Now, all the rules that we've talked about have to be obeyed if Mr. Broker has an escrow account. But if Mr. Broker doesn't have an escrow account, then obviously he's not concerned with that. And a couple of reasons that people don't want to maintain an escrow account today, Mr. Broker has to reconcile that checkbook every single month, and Mr. Broker is responsible for what money's supposed to be in there, what money is not in there. So if anything goes wrong with the escrow account, it's Mr. Broker's problem. And so Mr. Broker oftentimes, just to shield himself from that aggravation, as well as what we call overwhelming temptation, a lot of brokers today don't have an escrow account, or they certainly don't escrow all their money at escrow. Here's what happens. Mr. Listing Agent has a listing. Another company brings in an offer on Mr. Listing's listing. And they say, we've escrowed the money with the XYZ title company. All right? If they do that, they have to put the name and the address and the phone number of XYZ Title Company in the contract. Now, Mr. Listing Agent, not Mr. Other Agent, Mr. Listing Agent has a responsibility to check with the XYZ Title Company within 10 days and verify that that money is in fact in their escrow account. Now, the reason for that, 30 days later the deal falls apart. Mr. Seller says, well, forfeit the escrow deposit to me. We find out it was never deposited in the escrow account. So the listing broker is bound to verify that it's there. Now, the only time that would not be true if we use the listing broker's choice of title company. But if we're at the other broker's choice of title companies, Mr. Listing Broker owes it to his client to verify that situation. Now, also, if that's done, and that's pretty much all we need to know about escrow accounts. Well, not quite. Mr. Real Estate Broker can have an interest-bearing or non-interest-bearing escrow account. Now, if Mr. Broker has a non-interest-bearing escrow account, obviously there's no concern with the interest. But if you have an interest-bearing account, there's 3 people that might be interested in getting that interest: Mr. Seller, Mr. Buyer, Mr. Broker. Here's the deal. If Mr. Broker is going to get the interest, he needs permission from the buyer and the seller on every transaction. If Mr. Seller is going to get the interest, we need Mr. Buyer's permission. Mr. Buyer is going to get the interest. We, of course, need Mr. Seller's permission. And so if you have an interest-bearing account, you have to have the permission from the parties in order to get that interest. Also, sometimes we have a situation where we have a conflicting demand on escrow money. Now, this is when Mr. Broker has the money in his escrow account. For some reason, we have a contract. The buyer decides he doesn't want to close for what he thinks is a very valid reason. The seller says, no, that's not a very valid reason. You got to close. Either that or forfeit the deposit to me. So we have a conflict. Mr. Buyer says, give me the money. Mr. Seller says, give me the money. Well, here's a little memory peg for this. I call it no meal. I call it no meal because here's the deal. No matter what happens, I'm not going to make any money. I'm not going to put any cornbread on my table. Now, the no is for notify the FREC that we've got a problem. Mr. Buyer says, give me back the money for what I think is a good reason. Mr. Seller says, no, give the money to me. The first thing Mr. Broker's bound to do is notify the FREC we've got a conflict. You're bound to do that. And you're bound to do that within 15 business days. 15 business days from when? From the last demand for the money. Buyer says, give me the money. Day after tomorrow, seller says, give me the money. We're bound to do it within 15 days of the last demand for the money. Now, within 30 business days, we are bound to do something with the situation. In other words, we can't just sit around and do nothing. Now, one of the choices we have is we can mediate. Now, what that means is we hire a professional mediator, we pay him a fee, we all sit down at the conference table, and hopefully we can come to an agreement. If we can't come to an agreement, oh well, we'll try something else. Now, another choice is arbitrate. Now, arbitrate is where we hire an arbitrator, a little bit more expensive. Now, the difference between a mediator and an arbitrator is this. With an arbitrator, we will come to an agreement because we all agree before we start, we will obey the arbitrator. So Mr. Buyer says his piece, Mr. Seller says his piece, Mr. Arbitrator tells me, Mr. Broker, give the money to the seller. I give it to the seller, that deal's done because he has the power from that we all agreed to let him have the power. Now another choice is litigate. Litigate. That's what we do with lawyers down at the courthouse before the judge. Now there's two types of litigation. There's a bill of interpleader. There's a bill of interpleader, and there's a declaratory decree. Now a declaratory decree, this is when Mr. Realtor has some sort of interest in the money. I have an agreement in my original listing that if the money is forfeited back to the seller, I'm going to get half of it. So I'm not a disinterested party, I'm an interested party. So we would petition the court for a declaratory decree, sometimes called a declaratory judgment. Now sometimes Mr. Realtor has no interest in the money. Maybe it's only $500 and I don't really care what happens to it. Best case scenario, I'm going to get half of it, and I believe it's going to be forfeited back to the buyer anyway. So I don't have any interest at all. In that case, we could petition the court for a petition or bill of interpleader and say, Mr. Judge, you got the money, you take the money, these two guys will be in touch, I'm out of here, adios. And that's not a bad choice. Now another choice is a escrow disbursement order. Now, an escrow disbursement order, this is where we petition the FREC, those 7 big shots, and say, hey, 7 big shots, would you tell us who's going to get the money? Now, by the way, on the test, you might see this called an EDO, testing your knowledge to know what an EDO is, escrow disbursement order. Now, here's the deal. With an escrow disbursement order, we ask the FREC to settle this. Well, what they do, they send out a questionnaire to the buyer, questionnaire to the seller, questionnaire to anybody who's got any interest in it, including the realtors, and based on that, they say give the money to the whomever they say. So they say give the money to the seller. Well, the buyer says, to heck with that, I'm going to sue you. So now, by the way, you don't have to order an EDO, but once you do, you have to obey it. So they say give the money to the seller. Mr. Broker is bound to give the money to the seller. Mr. Buyer sues Mr. Broker, and the judge says give the money to the buyer. That's a bad situation to be in, don't you all agree? Well, here's the deal. Do you remember the Real Estate Recovery Fund? The Real Estate Recovery Fund is this giant fund of money that we have that says we originally put this money in the escrow, in the fund to protect the general public from brokers. Well, since the money's in the fund, FREC used it to protect themselves from bad EDOs. So now the judge says give the money to the other party. The recovery fund will pay that judgment, they will pay the court cost, and they will pay both attorney fees if so ordered by the court. And so they will do that with no consequence to Mr. Realtor. Mr. Realtor's not going to get his license suspended, and Mr. Realtor doesn't have to pay the money back. And so that's how that works with you obey an EDO. So the Real Estate Recovery Fund takes care of that. Now let me back up and remind you, the first thing we're bound to do is notify the FREC that we have a conflict. Well, the truth is there's 3 occasions where we don't have to notify the FREC. One of those occasions is if we sell a HUD home. That's a home where the home belongs to HUD, the United States government, Housing and Urban Development. You sell a HUD home, HUD says give us the deposit, that's the end of the story. You give the deposit to HUD, you don't even have to notify the FREC of that conflict. Another time is when you sell a residential condominium. When you sell a residential condominium with Mr. Developer, brand new condominium, you got 15 days to rescind the contract. Joe Average to Joe Average, you got 3 days to rescind the contract. We tell Mr. Seller that, but he forgets. 2 days later, buyer backs out. Seller goes ballistic, says, no, give me the deposit. No, we're giving it back to the buyer, and you don't even have to notify the FREC of the conflict. And the last case is a financial contingency. Same story. We tell Mr. Seller it ain't a done deal till the loan's approved. And turns out 29 days later, the loan's not approved, even though the mortgage guy told us this guy is wonderful. It's not approved. In that case, you don't have to give the deposit. You give the deposit back to the buyer as required by the contract, and you don't even have to notify the FREC of that situation. Any other time, you're bound to mediate, escrow disbursement order, arbitrate, or litigate. Of course, you're bound to do that even with those, but now, we talked about EDOs. There's another thing, and that is rental list. If Mr. Real Estate Broker is selling rental list, that's list of properties that are for rent. Now, when you sell a rental list, you're bound to give the buyer, he pays $100 for the list, you're bound to give him a receipt that says, if you don't find a rental, for whatever reason, I'll give you 75% of the fee you paid me back. And if you find this list is inaccurate or inappropriate, I'll give you all your money back. So if the list is no good, they get all their money back. Now, let me tell you all this, and this is something new. Sometimes there's a problem with Mr. Realtor getting paid a commission that he's justly owed. One of the ways that you can avoid that problem, if Mr. Broker has a provision in his original contract giving him permission to place a lien on the property, Mr. Listing Broker can put a lien on the property for his commission. And if you don't have that in your original listing, you can't do that. But if you do, you can. Now, if you didn't have that in your original listing, but Mr. Broker felt like this guy's not going to pay me, and so he took it upon himself to go put a lien on that property when he didn't have that permission in his original listing, that could be a suspension offense to do that. But if you have permission from the seller, you can do that, but otherwise you cannot. Now, in commercial real estate, oftentimes commercial realtors will place a lien not on the property, but on the proceeds of the sale that the seller is going to get. And that's done through Part 3 of Chapter 475, and it gives that broker the right to place that lien on there. Now, Commercial Real Estate Leasing Commission Lien Act, a lot of times when commercial realtors are leasing property, sometimes the tenant agrees to pay a commission to the realtor. If that's the case, they would place a lien against the tenant's leasehold interest. Sometimes the landlord, the shopping center owner, will agree to pay their commission. In that case, if they had permission in their original listing, they could place a lien against the seller's property for their commission. Now, let me remind y'all, Mr. Broker cannot pay any kind of fee to an unlicensed person. If my next door neighbor came over and said, Ron, a friend of mine at work wants to sell his house. Why don't you get in touch with him, list his house, and pay me a couple $100 for hooking you up with it? No, no, no. That's a violation of Chapter 475 for me to do that. I can't pay an unlicensed person a fee for sending me a customer or anything of that nature. Now, what if Mr. Georgia broker or Tennessee broker or California broker sends me a prospect down here? They can do that, and I can pay them a fee so long as they stay in their own state. Now, if they come to Florida and become present in the negotiations and the sale, they need a Florida real estate license. I don't care if they got a license in 49 states. If they don't have a license in Florida, don't come to Florida, but I can pay them a fee as long as they stay in their own state. And this is the premise that Century 21 and Remax and Coldwell Banker and all of these big franchises, they make a lot of money sending those referrals to other states and other places. By the way, today, don't forget the commission is always paid to the broker, but today the broker can instruct the closing agent to give the check to the salesman. So there's a $10,000 fee. The salesman's on a 60-40 split. They give him one check for $6,000 made out to Mr. Salesman, another check for $4,000 made out to Mr. Broker, but it has to be at the broker's instruction. And that Zephyr Hills water is good. Now, the next thing we're going to talk about is kickbacks. Let me remind you, whenever I sell a house, it's not unusual that other people will make money. Other people like Mr. Surveyor, Mr. Appraiser, Mr. Home Inspector, Mr. Termite Inspector. And I might want Mr. Termite Inspector to give me $20 for sending him that business, or Mr. Surveyor to give me $50 for sending that business, or Mr. Title Insurance Company to give me $100 for sending them that business. RESPA, Real Estate Settlement Procedures Act, says no, you cannot do that unless it's in the closing statement. Now, if it's in the closing statement, everybody looking at that closing statement knows I'm getting $20 from the termite guy, $40 from the surveyor. That's okay if I'm properly licensed to receive those fees. Now, we're not tested on other professions' rules and regulations, but I think we all know you need some kind of license to get insurance, like title insurance or hazard insurance, and likewise a mortgage. So unless I have a license for those, I can't be receiving fees from those people. Now, all Chapter 475 says is we have to tell the people that we're getting that fee. So I say, Mr. Bauer, I'm getting $20 from the termite inspector. That's okay. Now, let me talk to y'all again. I talked to you earlier about the word realtor. R-E-A-L-T-O-R, spelled with a capital R on the test. Always has this little gizmo on the test. Now, if I'm not a member of the board of realtors, I can't go out and tell people I'm a realtor. If I say I'm a realtor when the truth is I'm too cheap to pay the dues, that is a violation of Chapter 475. Also, even if I am a realtor and I want to say, well, I'm a member of the Society of Industrial Realtors or some prestigious group within the Board of Realtors that I'm not really a member of, that's a violation to claim to be a member of something when you're not, whether it's the Board of Realtors or some organization within the Board of Realtors or any organization for that matter. And so we can't claim to be a member of something when in fact we are not. Now, I'm going to erase all this and I'm going to talk to you about several business entities that can get a real estate license. Now, let me tell you what I want you to pay real close attention to as we go along here. Number one, I want you to pay attention to the entities that can get a real estate license. I'm going to put a list of 7 up here on the board. Then I want you to pay attention to the people involved with these entities that must be a real estate broker in order to be an officer or a director with corporations or a general partner with partnerships. I also want you to pay attention to the paperwork that brings them into existence. Now, the first one we want to talk about is a sole proprietor. Now, a sole proprietor, this is when somebody just goes into business and starts working. I operate my business as a sole proprietor. It's just me. If I went out and sold a house, they make that check out to Ron Clymer. That's all there is to it. There's my sign, Ron Clymer, licensed real estate broker. By the way, it's Ron Clymer, licensed real estate broker. I don't operate under a trade name. Now, if I had a trade name such as Clymer Realty or Acme Realty, I would need to register that trade name with the DRE. Now, what a trade name is a name other than Ron Clymer. So if I'm doing business under the name of Clymer Realty, that's a trade name. I have to register that trade name with the DRE. Now, here's the downside of a sole proprietor. If I'm a sole proprietor, I've got 10 agents working for me. One of those agents goes out and commits fraud, accidentally or on purpose. Person that's been defrauded can sue that agent, but they can also sue me. They can sue me personally. They can get a judgment against my personal real estate, my personal house, my personal car. And if I have any assets, they can take those assets to satisfy those judgments. And so if you stop and think about it, that's a little on the dangerous side. Now, I might choose to open a corporation for profit. Now, a corporation for profit, this is where I form a corporation. Now, the way I do this is I file documents with the Department of State called Articles of Incorporation, bringing this into existence. Now, a corporation is separate and distinct from Ron Clymer. So if I formed Clymer Realty, that's a corporation. It exists. It can do anything that Ron Clymer can do. It can own property, it can owe money, it can sue people in a court of law, it can be sued by people in a court of law. It can do anything a person can do except die unexpectedly, which is pretty cool. Because if I'm Ron Clymer, the sole proprietor, I died unexpectedly one day. Nobody expected me to, but I'm gone. I no longer exist. And neither do any of those contracts that my 10 agents have. Just ignore that bell. Now, if I'm Clymer Realty Incorporated, Clymer Realty Incorporated exists separate and distinct from Ron Clymer. And so Clymer Realty Incorporated has those 10 employees. One of those employees commits fraud. Person that's defrauded doesn't sue Ron Clymer, sues Clymer Realty Incorporated. Would have a judgment against Clymer Realty Incorporated, not against Ron Clymer. And that protection from personal liability is a major reason for corporations. Now, by the way, if I'm a corporation, now, who runs a corporation? Officers and the board of directors. So if the corporation is a real estate brokerage corporation, the officers and the board of directors have to be a broker of some sort. What do I mean by that? Well, an active, qualified, went-to-school broker, such as myself, could be a broker. Could be a officer or be on the board of directors. Well, let's say I wanted a friend of mine to be on the board of directors. Let's say my friend is a retired real estate broker. He's got plenty of money, doesn't need to work. And I said, listen, I want you to be on my board of directors of Clymer Realty Incorporated. Then he could do that with his inactive license. Now, I can't imagine that happening in real life, but it could happen on the test. Also, I want my brother-in-law to be on the board of directors. Now, my brother-in-law has never been in real estate school, never had a real estate license, but he wants to be on the board of directors. He can apply for and receive registration status, giving him the ability to be on the board of directors. Now, neither he nor my retired friend can go out and sell real estate and earn commissions, but they can be on the board of directors, or they can be an officer of a corporation, or they could be a general partner, which we'll talk about in a minute. And I think we've got a situation going on here, a time thing, and so I'm going to see you on the next tape. So Be right back.